This morning we're having a hearing about the National Labor Relations Board's new rule on union elections. Senator Murray and I will have an opening statement. Then we'll introduce our panel of witnesses. We thank them for coming. And after their testimony, senators will have 5 minutes for questions. Last December, the NLRB issued a final rule that shortened the timeline between when pro-union organizers ask an employer for a secret ballot election and when that election takes place. I refer to this as the ambush election rule because it forces a union election before an employer has a chance to figure out what's going on. Even worse, it jeopardizes employees' privacy by requiring employers to turn over personal information, including email addresses, phone numbers, shift hours, and locations to union organizers. For that reason, Senator Enzi and I and Senator McConnell have introduced, under the Congressional Review Act, a resolution of disapproval, which we expect the Senate will act on after the recess. Today, more than 95% of union elections occur within 56 days of the petition filing. But under this new rule, elections could take place in as few as 11 days. The rule will harm employers and employees alike. Here's how. If you're an employer who gets ambushed on day one, you get a fax copy of an election petition that has been filed at your local NLRB regional office stating that 30% of your employees support a union. The union may have been quietly trying to organize for months without your knowledge. Your employees have heard only the union's pitch. By day 2 or 3, you must publicly post an election notice in your workplace and online if you communicate to your employees electronically. By noon on day 7, you must file with the NLRB what is called a statement of position. This is a comprehensive written document in which an employer sets out legal positions and claims. And under the new rule, you waive your rights to use any legal arguments not raised in this document. On day 7, you must also present the union and the NLRB with a list of prospective voters, as well as their job classifications, shifts, and work locations. Then, on day 8, a pre-election hearing is held at the regional office and an election date is set. By day 10, you must hand the union a list of employee names, personal email addresses, personal cell phone numbers, and home addresses. Day 11 is the earliest day on which an election could be held. Under this new rule, the union can postpone an election by 10 days at this point, but the employer has no corresponding power. Under this new NLRB rule, before the hearing on day 8, an employer will have less than 1 week to figure out what an election petition is, to find legal representation, to determine legal positions on the relevant issues, to learn what statements and actions the law permits and prohibits, to gather information required by the NLRB, to communicate with employees about the decision they're making, and to correct any misstatements and falsehoods that employees may be hearing from union organizers. Making even the slightest mistake in the lead up to an election can result in the NLRB setting aside the results and ordering a rerun election, or worse, the board could require an employer to automatically bargain with the union. But it is the employees who stand the most to lose under this rule. First, because of this ambush, employees will hear only half the story about what unionizing will mean for them and their workplace. As the 2 dissenting members of the NLRB put it, employees will be asked to vote now, understand later. Second, they lose their privacy because the rule requires employers to hand over employees' personal email addresses, cell phone numbers, shift hours and locations, and job classifications, even if the employee has said he doesn't want to be contacted by union organizers. This rule appears to be a solution in search of a problem. Only 4.3% of union elections occur more than 56 days after the petition filing, and the current median number of days between a filing and election is just 38 days. These figures are well within the NLRB's own goals for timely elections. Unions won 64% of elections in 2013, so the union win rate has been going up. Finally, in a 1959 amendment over debates to the National Labor Relations Act, then Senator John F. Kennedy warned against rushing employees into an election, saying, there should be at least a 30-day interval between the request for an election and the holding of the election in which both parties can present their viewpoints. That was Senator Kennedy's view. It's clear to see the rule is wrong. That's why we've introduced the Congressional Review Act resolution. will ask the Senate to disapprove the NLRB's new rule and prohibit it from issuing any similar rule. The House will follow a similar process. I hope the full Senate will agree. Senator Murray.